Hello, welcome to a very special and exclusive interview today. And my guest today is Justice S. Muralidhar. And he is now present. He is practicing before the Supreme Court of India. And as a judge, he was widely respected for his uncompromising integrity, judicial independence, and commitment to constitutional values. He has since been vocal commentator on the Indian judiciary across national and international platforms. Most recently, he has edited a big volume, Incomplete Justice 75 Years of Supreme Court of India, a landmark volume, really, marking the court's platinum jubilee. So we are deeply honored that Justice Muralidhar has agreed for this conversation, and I'm anticipating to this conversation for long. So I welcome you once again to this conversation. And
Thank you.
my first question is, in a recent, actually that was the point when I got hooked to it and I got interested in it. In a recent interview, you said that progressive interpretation of constitution. Why progressive interpretation? Why just not interpretation? So that really, I found that very fascinating.
So the Constitution itself was made, as you know, in 1949. In fact, when they signed the final draft of the Constitution, it was 26th November 1949. And that's close to 76 years, 70 now. And during this time, society has progressed, uh, thinking has changed, several generations have passed. Certain eternal constitutional values, which our constitution makers hoped will be preserved, are still something that we cherish and we want to be guided by. But every generation looks upon this document with a renewed hope and with a fresh set of ideas. So the earlier generations have now to give way to the present generation's way of thinking. And the constitutional interpretation has to accommodate these changes. So judges are deeply conscious of this fact. In fact, you will find in many judgments of the Supreme Court, they look upon the Constitution as a living document, which has to reflect the values of the modern day society. So when judges pick up that document, they are aware of how their predecessors have looked at the document, but now want to give a fresh interpretation, a fresh viewpoint. And we would like this to be this way, which is why we use the word progressive. Progressive is in a positive sense. I'll just give you 3 or 4 examples just to make good this point. In 1950, when they sat down to decide a case involving preventive detention of a communist leader, Mr. A.K. Gopalan, it was a bench of 6 judges. 5 of them, when they read Article 21, which says no one shall be deprived of life or liberty except according to procedure established by law, they looked at that law as merely a statutory law, which had to be a statute enacted by Parliament. And the law in question in that case was the Preventive Detention Act of 1950. So the thinking of 5 of those judges was that as long as there is a law enacted by Parliament, the requirement of Article 21 stands satisfied. But one of the judges on that bench, Justice Fazil Ali, thought differently even in 1950. He said this law can't be merely a law. It has to be something more. Because he looked at the words life and liberty as not merely encompassing the actual life of a person, but of the facets of life. See, he says, what is a preventive detention order doing? It is restricting the freedom of movement of this person. So there is a freedom granted under Article 19 of the Constitution, a freedom of movement. So he said this life will become meaningless if I don't have the ability to move freely. Of course, subject to reasonable restrictions, but your movement can't be stopped. So, and also if you're detained, your liberty is curtailed, and that detention has to satisfy the requirement of Article 22. So, way back in 1950, this judge saw an interlinkage between these three freedoms, these three fundamental rights. It took another 20 years for a different bench of 9 judges to say that what Justice Fazal Ali said in 1950 actually makes sense. So then the law progressed when it came to the bank nationalization case, and they were looking at the same set of fundamental rights. What Justice Fazal Ali had said should be the interpretation appealed to them. 8 years later, in Megha Gandhi, the court actually formally declared the interlinkages between various fundamental rights and said we can't see them in isolation. They have to be seen as a scheme. So this is what I mean by progressive interpretation. As years go by, the judges bring to the fore the present day thinking, which reflects the societal values of that period. Having said this, it's not always something that we hope for or wish for. This again has an uneven kind of a progress. Let's look at the word sex appearing in Article 15 of the Constitution. No one can be discriminated against on the basis of his race, place of birth, descent, or sex. It says one of those criteria is sex. Now, does the word sex include sexual orientation? This was a question that arose when Section 377 of the Indian Penal Code was challenged because it had criminalized even consensual acts of same sex between adults. So when we were dealing with this challenge in Nas Foundation in the Delhi High Court, the two of us, Justice Shah and me, we were prepared to read the word sex as including sexual orientation. We saw this as something that is innate to a person, and no person should be criminalized for what is natural to that person. Now, that interpretation which we had given in the year 2009 met with disapproval by the Supreme Court in 2013 by another two judges.
Yes.
And then it took another 4 years for a bench of 9 judges in the Justice Puttaswamy case to say, no, what the Delhi High Court said in Nas Foundation is actually the correct way of appreciating the word sex. So the progressive interpretation met with the resistance in the Supreme Court in 2013, but met with approval in 2017. So this is something that it's quite fascinating to watch how progressively, you can interpret various provisions of the Constitution to reflect the modern day values of society.
Great. Because the society is changing, the reality is changing. So,
Correct.
a statute, a law which is enacted, if it is not interpreted,
Correct.
taking into account of the changing
Yes.
situation, then of
Correct.
course it will be stale. It will not be
Correct.
able to respond
Correct.
to the challenges of the present time. Thank you very
I
much
just want to
for.
also add, even in the United States, there are two camps in this constitutional interpretation exercise. One are the originalists. You'd heard of the name of Justice Antonin Scalia.
Yeah.
He was very firmly of the belief that the way the Constitution was written there in the United States in 1776, that alone should be preserved. He said it's not open for us to keep interpreting it any which way we like. We have to respect the original intention of the Constitution makers. And if you want to change that wording of the original intent, Constitution makers, you can only do it through the legislative route. But there is another school of thought there, which has fortunately prevailed, which agrees with this kind of interpretation that I spoke of, that the Constitution is a living document and has to reflect the modern day values of society.
Yeah, because
So this contestation, but fortunately for us, the judges of the Indian Supreme Court, by and large, have subscribed to the view that it's a living document which should reflect the modern day values.
No, actually, thing is that so what is written in words, we also need to uh, read the intention of the words, isn't it? And the intentions are
Correct.
evolving,
Correct.
evolving. Hmm. So now
Correct.
yeah,
Correct.
yeah.
Correct.
Intentions are evolving. Now I come to the next question.
Yes.
um, See, in your book, actually, in that I today in the morning, I actually got it counted. The introduction of your book. It is there. I
Okay.
did little more than 8,000 words, including the notes.
Yes. Yes.
And it is such a comprehensive actually analysis of the Supreme Court of India, and rather the judiciary, Indian judiciary. It's really very, very interesting and enlightening. Now, in that introduction, you mentioned that there have been many changes. So far, the infrastructure is concerned, new technology is introduced, and I would not like to
Correct.
name the CGI, one CGI. I would not like to name him because in one of the meetings he was so elaborately speaking about the new technology and infrastructure. But the thing is,
Right.
technology and infrastructures, they're definitely needed. But how have the technology and infrastructure, first thing is that how have they reached out to the larger section of the people, number one, and number two, how have actually they enhanced the quality of justice delivered?
I really appreciate this question of yours. I think what you're referring to is my one part of my introduction. But I must also share with your viewers that there is a whole chapter in this book that I have written on digitalizing of the judiciary,
Yes, yes,
the
I think
various
you were
steps
involved in it, that.
that and stages that we passed through
Hmm.
for the last 30 years in this exercise of digitalizing. So when we use the word, yes, when we use the word digitalizing, it's not merely digitizing the papers into soft copies, but also the processes. So it's a combination of several things. That's why we use the word digitalization. Now, if you read that chapter, you will find that there are many processes that have become easier because of technology. Just to give you a small example, now sitting in Guwahati or even Shillong, you can choose to watch what is happening in the Supreme Court of India.
Yes, 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 yes.
Let us say the litigant is actually in Shillong
Hmm.
and his case is being taken up in the Supreme Court and heard by the Supreme Court. The litigant does not have to travel all the way to New Delhi to know what is happening in the case.
That's great. Hmm.
Sometimes his lawyer can also appear from wherever that lawyer is sitting before the Supreme Court of India. Now, if you ask me in the year 2010, even, is it possible for somebody sitting in Kanyakumari
Hmm.
to appear virtually in the Supreme Court? I would say, sir, it's still a far cry off. We still have a long way to go. But when COVID happened in 2019, in 2020, March 2020 is when COVID happened. It compelled all the courts to get onto the digital platform. And it was not confined to either the High Courts or the Supreme Court. Even the district courts had to get onto the digital platform. Fortunately for us, the broadband was available, the bandwidth was available, 4G technology was available. So it was possible, therefore, for not only cases to be filed using email as an attachment to the email, you could send a petition to a court, but also to be heard, to argue your cases using either the Zoom link or Google Meet or a video that program developed by the National Informatics Center. So the whole COVID-19 interlude for almost 2 years was a big change, and many judges were introduced to this concept of hybrid hearings. Some of us in the high courts, whether it's the Delhi High Court or let's say Kerala High Court or even Karnataka, had already started using paperless mode of functioning. We had digitized our papers and we were already having monitors on the dais and we were reading our petitions on that monitor. We were making our notes with a digital pen on that. So all this started in 2010 in Delhi. And even within the Delhi High Court, let's say 4 or 5 of us were prepared to do this. The other judges were a bit reluctant because they had to teach themselves how to use this technology. So COVID changed that. So all judges came on board. So in terms of the ease of functioning, technology is a big help. In most courts, you will find that the corridors are filled with cupboards, which are filled with files. Even inside a courtroom, you will find on the dais, below the dais, lots of files, and it's overflowing with paper. If you walked into the back offices of the court, we call it branches, you will find that clerks are working with papers, mountains of paper, all falling all over them. Many of them are standing and working because there are files on the table, files on the chair, files on the floor. So what technology has helped us do is, by resorting to digitizing of the files, it has helped free up space. So when I was Chief Justice of Orissa for those 2.5 years, we took it on as a major exercise, this digitization of not only the disposed of files, but even the current files. And we also facilitated reception of files. That is how papers will be received. They will be received in soft copies in the court. So progressively, we reduced the accumulation of paper in the courts. And we did not stop with the High Court. We went down to the district courts as well. So technology actually helps you free up space in the courts. It makes it a freer place for you to function, whether as a peon or as a clerk or a section officer, and definitely as a judge. So you can see the freeing up of space tangibly. So in terms of functioning of the court, technology is very useful. In terms of access to justice, like I pointed out, you can today file cases in the Supreme Court of India from Shillong. You can use e-filing technology. There is a whole step-by-step, guidance given to you. Some find it a bit difficult, but increasingly many people are filing their cases online. And suddenly you get more time to file. So in a physical format, you have to reach before the court's closing hours for limitation. If the filing counter stops at 4 o'clock in the evening, you have to somehow rush and file it before 4 in the evening. But on a digital platform, you can go up to midnight. Yeah, anytime up to midnight. So all these facilities are available. It's ease, but there is also a flip side to it. And many lawyers have voiced that concern. One is the digital divide. Some of these things require you to have what are called smart devices. While these are becoming progressively more affordable, there is still a large part of the legal community where lawyers cannot afford these smart devices. So to overcome this digital divide, what the courts have done is set up kiosks, filing kiosks, help centers, where a lawyer can bring the hard copies, have it digitized and filed in the soft format in the courts. What you were otherwise asking about quality of justice, you cannot make a direct correlation between these two things because it does not automatically ensure better quality justice. Let's say I was writing a judgment by hand, and today I'm using a typewriter. Your question is my judgment going to be a better judgment? Is it going to have a better reason because I've used the typewriter instead of writing by hand? The answer is no. Because this is only a tool. This technology is a tool. How I function as a judge, what kind of reasons I give for my orders, how do I conduct the proceedings, how do I eliminate bias in my reasoning or the manner of dealing, all this depends on me as a judge. The technology will not improve that kind of functioning. It will make functioning more transparent, like live streaming makes the functioning more transparent. You know when the judge is in a good mood, a bad mood, when the lawyer is performing well, when the lawyer is not prepared. It is there for you to see now. There are so many millions of people watching all of this. So in a sense, As a lawyer, since I'm aware now there are people watching, I'm more careful in the way I address arguments in court. And I dare say some of them would be better prepared, knowing well that the client, although not physically present in the court, is probably sitting in the
Watching
drawing
it.
room of his house and watching me perform. So I cannot no longer tell the client, no, 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 the judge did not let me argue, or the judge was too busy, the other side was not ready, and therefore it had to be adjourned, because all that is there now for the client to see. And the client is also able to tell the lawyer, listen, that other lawyer argued this, why did you not argue this? So all that is now there on display. So somewhere technology is making us more aware. I would say it will help us become more accountable to our
Yeah.
clients. So this can't happen overnight. This change is not tangible overnight, but slowly it might improve.
Now,
Right.
I was just telling in response to your answer, I want to say there's a subtle, actually, if we have to say these are not, one thing is not very much connected to the other thing. That means infrastructure, technology, and intrinsic value of a judgment. So, and while we all appreciate that actually we need infrastructure, we need say modern technology to be introduced into it, but then that does not automatically actually lead to a better
Yeah. Yeah.
quality
It
of
all depends on
judgment.
how
Yeah.
I use, yeah, how I use this. For instance, today, if I want to know in my court, what are the 10-year-old matters? What are the 20-year-old matters? What are the 2-year-old matters? I can use technology to analyze the entire, set of cases before me. And as a judge, then I can plan my day's hearing. So what we called as court management technique. And within a case, the technology can help me understand how many times this case has been listed, who has been responsible for the adjournments, and what stage is the case in, and whether I should give a long date or a short date. So technology can help me plan the hearing. So if I'm able to prioritize my cases, if I'm able to give more attention to old cases using technology, it might improve the quality of my functioning. But
So
the outcome in a particular case may not by itself change unless I do what
yes,
I'm essentially
yes,
supposed to do, which is why this using this artificial intelligence, we very very casually say, oh, why don't we use artificial intelligence to even decide the cases? And that's a dangerous proposition,
yeah, yeah.
because
Then yeah.
in many of
This
the
question,
cases, yeah, we have an element of discretion. When we take up a case, we know the want to know the background of the litigant before us, particularly in criminal cases when it comes to sentencing. Suppose I have a range to of sentence to award. Let's say between 0 and 7 years. There are so many factors that will go into my ultimate decision whether I should award a 2-year sentence or a 3-year sentence or a 4-year sentence. We can't have a too rigid formula on this. Whereas AI will work on some kind of a formula, and that might result in severe injustice if you apply it mechanically.
yes, yes,
So I don't think we are ready for that kind of an application of those kind of decision making software. We should be very very guarded and careful before we even attempt to use that kind of a software for substituting what the judge should be doing.
yes, surely, because it will only say it is all algorithm. It is all algorithm. So that is why one has to very careful about it. And what I say is
Correct.
these days, so where even the education and other things are concerned, I say that okay, the answer is easier, but the question is difficult. When we deal with this artificial intelligence,
Yeah,
the
yeah,
question, one has to
correct,
put intelligent question. The
correct,
answer they will can get the answer, but then question you must have the question must be original. That's very important,
correct,
I think. Yeah.
correct,
So
correct,
now I
correct.
come to next question. Actually, in a way, the next
Yes.
question is related to the earlier question also. Now, but let me put it, and I would see how you respond to it. You have cited some
Hmm.
landmark judgments, both expanding and limiting constitutional values. At the end of
Hmm.
the day, are we doing better or turning worse? It's a small question, but the answer.
No, I'm an eternal optimist. So the way I look at it is that our democracy is a work in progress, and our systems are also works in progress, right? We cannot have a perfect system. We cannot have an ideal system yet. The imperfections that we find in society get reflected in our institutions. So many of our institutions have their faults, their weaknesses, and the basic systemic problems that there are. So no system is free of all of that. And within that, churning, we are trying to find the correct solutions. So every now and then you will get a judgment which reaffirms your faith in the institution. And for every one such judgment, you may get perhaps two which disappoint you. So this is an ongoing process. It's very difficult to say that all decisions given by all courts at all times are progressive or regressive. It's a mix. Only 10 days ago, we had a very, very progressive judgment by the Chief Justice of India and another judge, and they said that grounds of arrest have to be communicated in a language that is understood by the détenu to the détenu. And if we find that the grounds of arrest have not been communicated, the arrest will be declared illegal. But more importantly, all steps taken pursuant to that illegal arrest will also be illegal. Now, this is not confined to just offense under the new penal statutes, but even those special statutes like Prevention of Money Laundering Act or the Unlawful Activities Prevention Act. So it applies to a range of statutes. Now, this I would consider a very progressive judgment. So this happened only 10 days ago. And then we are disappointed because somebody is in jail for 5 years or 6 years without trial. And the trial is nowhere near beginning.
and
And
it's,
yet the court is unable to find time to grant bail. So we are then disappointed with that. We say, how come, a person like this is suffering for 5 years plus without even trial commencing? What is the justice in that? So we have our positive moments, we have our disappointing moments. So we cannot, but this is the institution we have to engage in. These are the judges we have to engage with. And all judges do not think alike. I keep telling people, unlike other Supreme Courts in the world, ours is a Supreme Court which has 34 judges. I don't think any other Supreme Court in the world has this many judges. And our Supreme Court doesn't sit en banc. That is, they don't sit together. They sit in 15 or sometimes 16 benches. Those benches can be of 2 judges or 3 judges. Now, each bench is the Supreme Court of India. And any lawyer will tell you with the same petition, you go before bench A, they are likely to give one kind of a reaction to it. And that same petition you take to the next court, the reaction may be different. So it need not be consistent. It need not be, predictable. So there are moments when all this happens, where at one end you get judgments which are in line with what your expectations are as to protection of liberty, advancing the cause of the law. And there are others when you feel that the court has regressed and it has not taken the law forward. But this churning and this work in progress is something that is getting played out before our eyes. We should only hope, just like we hope in society, that better days will come when these positive moments are on the rise, and somewhere we must also contribute to it. We must also work at critiquing the code, which is why this book was important from my point of view, that I call it critical reflections. On the cover itself you will find Incomplete Justice, Critical Reflections, and this is an edited volume where we've got 24 contributors to speak fearlessly on what they think are the positive aspects of the court's functioning and the not so positive aspects of the court's functioning. So I will never give up hope. And I think we appreciate this as a work in progress. Our democracy itself however imperfect it is, it's the most valuable thing that we have. So we need the court to help us preserve those values, to carry it forth for the next generations, and make sure that the constitutional ideals that we've spelled out in the preamble are not forgotten, and that every time we come back to critique the court to say yes, you've stayed close to the constitutional ideals, no, you've gone away from that. So that is important for us.
Great. Now you are an eternal optimist. That's very good. But
Yes,
I
yes.
didn't frame I didn't frame that question. But then you mentioned it, as because you mentioned it, I would like to have your views also on this. That are someone who is waiting, who is in the jail, and the apex court is not even able to decide. And we always say that, okay, the bail is the rule, jail is the exception. Now, here is a case, somebody is in jail for 5 long years, and we are yet to decide. How do we respond to that?
Yes, so this is again the inconsistencies in the court's approaching. So, had this bail petition gone to some other set of two judges, it's very likely that they may not have taken so long to come to a decision, and they may have come to a decision much sooner. So, this all again varies widely from court to court. It should not be this way. I agree with you, it should not be this way. It then becomes what people call as a judicial lottery, that by chance your case came before a bench of two judges who were liberal, or by chance your case went before a bench of two judges who were conservative. So it should not, these matters like bail, where principles are clearly set out, because ultimately you have to ask, do you still really need to retain this person in custody? Is this person a flight risk? Is this person likely to influence witness and tamper with the evidence? These are the questions that are normally asked for grant of bail. But what is making it difficult is the parliament has inserted certain provisions in the statutes, particularly like UAPA and the PMLA, which make it difficult for a person to obtain bail unless the person is able to demonstrate the person's innocence, which is so difficult without trial actually commencing. At the stage of a charge sheet having been filed, where all the material that is there before the court points to your guilt, you're somehow supposed to demonstrate to the court that you have to read these materials in a manner that actually demonstrates my innocence. So it is that much more of a difficult mountain to climb for an accused. It is here that the court has to come with a more progressive way of interpreting these provisions to say it can't be stretched to an absurd limit of keeping a person in custody for 6 years and 7 years when the trial has not even commenced. And who is going to make up tomorrow if the trial commences and you actually find there's no evidence against the person and the person gets acquitted? Who will make up for all these lost years? Right? So the court has to send out that message as well. Some benches of the court have done that in the recent past, but there are many benches which are not doing it. And I would also put some part of the blame on the lawyers themselves, not so much lawyers for the defense, but the lawyers for the prosecution. See, they're expected to be law officers. We call them law officers because they're supposed to take an objective view. They're supposed to correctly tell the court, listen, is this case made out for continued incarceration or not? On the other hand, we are finding them fight tooth and nail to oppose a bail, even in a case where a person has spent without trial more than 5 years in custody. These are the things that are actually coming in the way of us seeing complete justice being done in matters like this.
Now, here actually the two things come out of your observation. And one thing I feel very strongly about, that is, see, is why when we say that justice, how come the individual, the individual judge, how come the individual judge can interpret the particular thing from his subjective, from his perspective? Because it should be, there should be some element of objectivity in the analysis of the case. That's one thing. Another thing is that when you say that Parliament has actually enacted certain laws whereby it has become difficult for the person, the accused, to prove. The thing is that the actually that again comes to the basic structure thing of the constitution, all those things that, and even the philosophical background of jurisprudence, because whatever rule one frames, it must not go against the universal, you see, well, the concept of liberty, concept of, you see, equality, and whatever even enshrined in the preamble of our constitution. So
Correct, correct.
why then this subjective analysis of one? Why does then this one judge will take a liberal view and another judge will take a very conservative view? It's very unfortunate, I must
Yeah, it is unfortunate because there are enough judgments to give guidance to a judge as to how the discretion should be exercised. Like you have a checklist of questions.
say.
I
Yes.
gave you 3 or 4 instances, right? Is the person a flight risk? Is the person likely to tamper with the evidence? Is the person likely to conclude? Is the trial likely to conclude in the near future? So many judgments explain that these are the parameters you have to apply in evaluating the case and asking whether the person can be released on bail or not. Now, there is an element of discretion in each of these things. So, where 8 out of 10 judges would decide a certain way, 2 judges decide the other. And this is unfortunate because, we are now looking at the highest court. If the mistakes are committed by, let's say, the first level of the court, district court, it can be corrected in the high court. And if it's in the high court, it can be corrected in the Supreme Court. But in the Supreme Court, if you're going to have 15 benches of the Supreme Court, where one bench will look at the same material and react differently, then we have a problem in our hands. So, as lawyers, as prosecutors, we have to assist the court to say, now these are the settled parameters. On these settled parameters, a case is made out for bail. So, there are instances when the prosecutor actually tells the court that. He says, sir, we do not need this person further in custody. We need prosecutors like that, right? But
This,
we're finding them less and less. They're too scared to get up and say that, this is a case made out for bail. They leave it entirely on the court to say, now you decide whether the person should be granted bail or not. But these are under statutes, like, for instance, anti-terror statute. There's a level of already, caution that judge senses, right? That we cannot easily let out some persons. What will society feel? What is that overall message we are giving? So this kind of, fear at the level of the district courts, one is seeing it's very palpable, which is why you're never able to get bail at the level of the district court in some of these cases.
yes,
Even
yes, yes.
sometimes in the high court, everybody has to go up to the Supreme Court. So these are all unfortunate trends. So we have what is called judicial impact assessment studies. Every time you introduce a very stringent provision in the law, it increases the burden of the courts, because the court has to then be even slower in dealing with those petitions. It takes a longer time. And because these provisions tie up the hands of the judiciary, they're not able to grant the relief that they want to grant. So everybody is having to travel from one level of the court to the other, which increases the time, the costs, and those courts' dockets are all then filled up with these kinds of cases. So today, the Supreme Court, I'm finding that many of the benches in the Supreme Court are dealing with bail applications, anticipatory bail applications, which is perhaps not true of many of
Yeah,
the
they
Supreme
shouldn't
Courts in
be.
the world.
Yes,
The US Supreme Court is not going to decide somebody's anticipatory bail
yes,
application.
yes.
But our Indian Supreme Court is deciding those petitions today. So this is a sad commentary. So we are somewhere ignoring the empirical data that is before us, which demonstrates how the burden of the courts has increased phenomenally because we've made certain provisions of our statutes very stringent. So this is another area for correction, I would say.
I think whoever is actually watching this conversation, they should see it, they should watch it, that this should be underlined, that cases after cases coming to the Supreme Court for bail, it's very unfortunate. It is actually a poor reflection on the on our actually legal system. That's very bad, actually, in fact.
No, and at the other end, we are also complaining of overcrowding of jails.
Yeah.
So
Yes.
the government, when it instructs the Home Ministry,
Yes.
which
Yes.
instructs these lawyers,
Yes.
it should ask, what is it doing? On the
Yes.
one hand, you're making it impossible for
Absolutely. Absolutely.
prisons to
Because
function. Yeah,
yeah, I'll come to that, because you see, here is a book. We may not have that much time, but here is this book which says actually elaborately about the point you have mentioned here. Now, and but then I must say, and perhaps people who are watching it, they will also understand it, that your answers are so logical, so actually consistent with, and the statements, and when I'm actually listening to you,
right.
though at times I'm emphasizing on certain things, but in your everything is there in your responses, in your answer, and this is really enlightening.
All
Now
right.
I come to my next question.
Yes, yes.
This is we speak of independence of judiciary from the government,
Right.
but is it not a part of the state? Now the
Yes,
judiciary, it's a fundamental question.
correct.
Now judiciary, okay, we say that judiciary is free, autonomous from the executive. But one thing is that the concept of state is something different. Now,
Correct.
uh, so, but then this judiciary, is
So
it
there
not
are,
a part of the state?
yeah, so when you rightly pointed out, so there are organs of the state, right? So the three major organs we identify are legislature, executive, and judiciary. And we have an imperfect, I would say, we have an imperfect separation of powers in the Constitution, where each is expected to function in their domain. Like Article 13 of the Constitution enables the judiciary to judicially review statutes made by the parliament or even constitutional amendments made by the parliament to say, are these amendments valid or not? Are these statutes valid or not? And the judiciary is given the power to strike down those statutes. That does not mean the judiciary is encroaching upon the domain of the legislature. This is the constitutional design. Likewise, parliament can vote on the impeachment of judges, right? So there is a counterbalancing. Parliament can also enact laws, reenact laws which are struck down by the court by removing those elements which the court found problematic. So that is another exercise that is, envisaged in the Constitution. Third, decisions of the executive are tested in the courts. So there is a check on the executive by the judiciary, right? So it's a nice balance that the Constitution strikes. And the executive has a say in the appointment of judges. So there is an executive control over judges as well. The executive also holds the purse strings. The executive also holds the enforcement machinery, right? So judges can't function without a cooperating executive. If tomorrow a police officer in a district in our country decides that he is not going to execute the warrants issued by a court, the judiciary in that district will collapse. So they're completely dependent on the police to execute those warrants, to apprehend the criminals who are jumping bail. Even for service of summons, you depend on the police. So there is a balance that is struck in the Constitution where one organ cannot function entirely independent of the other, but each is a check on the other. So when we talk of the state, therefore, it's the larger concept of organs of state where they work interdependently. That's the correct word to use. But when it comes to government, when you use the word government, it means executive government. In
Executive.
fact, I have a trouble explaining to even judicial officers, please don't describe your current status as a government employee. You're not doing a sarkari naukri. I have to keep telling judges that. This is not sarkari naukri. Why? Sarkar is a litigant before you. Even at the level of the magistrate, it is, X versus the state. The state is a litigant before you. You are supposed to ask, the police officer is there before you. The prosecutor is demanding that, please extend the police custody by another 7 days. You may agree or disagree with him. Merely because he's the state you don't agree. He's the government you do not agree. So you are actually deciding inter parties. One major party before you is the government itself. At every level of the court, therefore, the government is a major litigant. Citizens are either against the government or the government is before the court. So at least 70% of all the cases at all levels of the judiciary, it's the government or government bodies which are the litigants. Which is why we say when we talk of pendency and arrears and all of that, if the government really seriously applies a proper litigation policy, where it will not continuously file appeals against every decision that goes against the government, the burden of the judiciary can reduce drastically. So since government is a major litigant before you, it's absolutely needed to have a degree of independence from that government, from that executive. And the independence we talk of is not at the level of just the Supreme Court and the High Court.
In
From
all
the level of
levels,
the state.
all levels.
Yes, and most importantly, the level of the magistrate. Because that magistrate is dependent on the government for the magistrate's functioning. Whether it's court infrastructure, security of the court campus. Because you directly come into contact with litigants face to face as a judge. And there are so many instances where the litigant is attacking a judge, and you need a vigilant, security officer there. So I'm saying that at various levels, when we talk of independence from the executive, we should allow that court to function freely and fairly. It's not only because Supreme Court judges and High Court judges take that oath. I will function without fear or favor, affection or ill will. As if that is not required of the magistrates. It's required even more there. So this explains why we need to be independent of the executive without any pressure from the executive whatsoever, and we are allowed to take decisions which can go against the government.
Great. No, actually, that means the law officers, the judges at all levels, they should feel empowered. They should feel empowered.
Correct.
Yeah. They should
Correct.
understand. They should know how much actually powers they have, and how they have to
Correct.
see it. Then why they should be scared of the
Correct.
government, because they are not the employee of the government. Yeah. Now, and here
Which
another
is
thing.
why we need orientation. Yeah,
Yeah.
we need orientation of these judicial officers. Many of them are very young, and it needs to be dinned into them all these concepts. The
Yes.
state is a different
Yes.
concept, and executive government is a different concept. Yes.
That should go into their blood, actually. That should go into their blood. Yeah. And here
True.
I remember one thing. It is in reference to your earlier observation. Falias Nariman, he famously said that, okay, who is supreme? He said that neither the parliament nor the judiciary, but the supreme is the constitution of India. And when there is a dispute concerning a law and act, now whatever is interpreted by the Supreme Court of India, that should prevail. So that is, he has very famously said these things.
Correct.
Now I come to my next question. There are not too many, but then, and these are a little long, so I'll read it out. The appointment of judges remains one of the most contentious issues. As Justice A.P. Shah and Justice Madan Lukur note in your book, the collegium system has serious loopholes.
Yes.
If, as Foley as Nariman said, the citadel never falls except from within, how do we safeguard the judiciary from decline through flawed appointments? And I have read this first three essays in your book. This is Sas, then Lacour, and the other one. And there are some hilarious things also said. So
Correct.
for the appointments of judges are concerned. So your response.
Yes, actually, we made the shift in 1993 where the primacy in the process of appointment was shifted from the executive to the judiciary. So till then, the executive had the last say on who should be appointed to the high courts and who should be appointed to the Supreme Court. They were, of course, consulting the Chief Justice of India as an individual, but that process was found to be unsatisfactory for a variety of reasons, which is discussed on those judgments, because it was seriously impairing the independence of the judiciary. Very often, if you read the contemporaneous writings of those times, you'll find that the Chief Justice of India was under tremendous pressure from the executive government to either appoint certain persons whom that Chief Justice of India was not inclined to, or not appoint persons which he was inclined to, because the government of the day seriously opposed such names. So the shift to this other system where a collegium now replaced the Chief Justice of India. The word consultation in Article 124, Sub-Article 3 was interpreted by the Supreme Court to mean concurrence. So it was not enough that there was a consultation with the Chief Justice of India. You had to have the concurrence of the Chief Justice of India before you processed a proposal for appointment. So that Chief Justice of India became the office of the Chief Justice of India, and that office was not a single member office, it became a collegium. So for appointments to the High Court, it had to be the Chief Justice plus 2 senior most colleagues. For appointments to the Supreme Court, Chief Justice plus 4 senior most colleagues. And if there was one dissent, it was acceptable. If it was two, there were not. That was not. So you had to have at least a 4-1 majority on appointments to the Supreme Court and transfers of judges from one High Court to the other. Now, in this system also, it is not as if the government has no say. The government gives very important inputs to the judiciary. For instance, the intelligence reports,
Yes.
the background check of the judges, that input is given only by the government. And the government can actually say in its report why it finds a certain name to be objectionable. The government can also give its comments on certain names and send it back. But if the court reiterates those names, then the government has to appoint. So there's a common misconception that under the collegium system, judges are appointing themselves. You know, in public platforms, you'll find this very loosely said, oh, judges appoint themselves in this country, and no other country do judges appoint themselves. It's not quite true. If anyone has watched what has happened in the last 11 years, many appointments are not going through because the central government is sitting on the file. Sometimes it is vocal in its opposition. Sometimes it just has like a pocket veto. It just sits on the file, says nothing, will not process it. And central government is not getting pulled up by going against the settled law by the judgment of the Supreme Court on the new system of how the collegium should function. So this is something that is getting played out in front of our eyes. So one trend that we've noticed is whether it was the pre-collegium or the collegium system, when you have an executive which comes with a big mandate in parliament, let's say 350 seats plus or 300 seats plus, that executive government with that kind of a mandate in parliament feels that it should have the final say on appointments of judges. This was there during Mrs. Gandhi's time. She had those huge majorities in parliament. And it is again getting played out in the current establishment in the last 11 years, where they feel, and you have those public functionaries go on public platforms and actually say this. How come with a majority like this, we do not have a say? You know, and who are these judges to tell us which are the best people to appoint to the courts? So this tussle is it's not new. What I'm trying to say is, it's a deja vu of a sort. So this is again part of democracy, but we expect judges to maintain that firmness and assert their independence, saying this is the law and this has to be followed. So it is a kind of statesmanship on both sides. We talk of judicial statesmanship, we should also talk of executive statesmanship. There should be a meeting ground on both sides, right? So they keep talking of Lakshman Rekha, this, that. But when people are watching the system, they know where the court has buckled and where the court has probably stood firm. Now, if you find increasingly it is buckling, then you know the independence of judiciary is getting compromised. So that is a cause for concern. So ultimately, it will boil down to who are the persons in that system at the given point in time. People very often ask me, okay, you find problems with the collegium system. Why don't we go back to the old system? We can't go back. Because if today the collegium system has created a hierarchy, it has created a hierarchy where a high court judge feels that that judge cannot, go against a Supreme Court judge at an individual level if he or she has to be considered for being appointed to the Supreme Court. So, you also tailor your behavior inter se with the judges of the Supreme Court in such a way that you're kind of seen as being subservient. But that's not the constitutional design. High courts were high courts in their own domain. The Supreme Court was not a superior court vis-a-vis the High Court. It was not a supervising court of the High Court. But the collegium system has made it that way. Now, if you dismantle this collegium system saying that this is not intended, let's go back to the older system. Human nature being such will then become subservient to political masters, which was happening in an earlier system where you were lobbying with, politicians to say, please consider my name for appointment as a judge. So we don't want to go back to that old system. What we learn over these years with both these systems is this. If the individuals in that system believe in judicial independence, irrespective of the kind of system, they will assert it. If persons in those systems are not innately wanting to assert their independence, then whichever kind of system you have, if these persons are in those systems, that system will also fail. So it comes down to actually individual. And this is therefore that debate which is inconclusive. Have we found those kind of persons who will assert their independence? That's the question.
So finally, it comes down to that, okay, you have to have your own backbone. You have to stand to the
No, and you have
challenges.
to see, you have to be uncompromising on your principles.
Yes.
Like
Yes.
I'm having a collegium meeting. My chamber juniors' names are being considered. Right? I should not be participating in this meeting.
Yes. Yes. And these are
A
actually.
relation of mine is being considered for being appointed as a High Court judge.
Mm.
I should not allow it to be coming before this collegium.
Absolutely. Absolutely.
I may retire and go. The succeeding collegium can take up that name, but I should not be part of it. See, there are some things which should be uncompromising. We should not be able to, we should not allow others to point fingers saying, where are your principles?
So finally, it is a question of actually integrity, impeccable integrity, and then only the system will work. And I think this you yourself also. I would not like to elaborate on this. You yourself also suffered for this thing. Otherwise, you would have become Supreme Court judge, isn't it?
I would say, yes, actually, I keep telling people this. I don't feel I have suffered. I had a
No, yeah,
wonderful
you are correct. No,
opportunity
no,
to be a High Court
absolutely,
judge.
you are absolutely correct. You didn't
Right.
suffer. We
Yeah.
suffered. You didn't suffer anything. A person who has the integrity, who has this confidence, why he will suffer?
Correct.
The system suffers. The Supreme Court suffered because they didn't get a person like you as this. You are
But
absolutely
yeah,
100% correct.
yeah.
Yeah.
No, but there are several others. I must say there were several
No, yeah,
others
I know. There
who
are many
got.
judges.
Yeah,
Yeah,
yeah.
there are many judges. Hmm. Now I'm coming to the next question is about this book.
Yes,
This
yes.
book. This
Correct.
is about
Mr. Teltumde's book. Yeah,
uh,
correct.
and Stan Swami's case. Now,
Correct.
how does
No,
it?
actually, these
It's
are the starkest cases. I think there can be no defense at all. First of all, we should not have picked up a person like Father Stan Swami, who's worked all his life for the tribals. It's a selfless service that he's rendered. Anyone who knows anything about Father Stan Swami will vouch for this. To say that he was sitting in some corner in Ranchi and being part of a conspiracy to kill the prime minister is all so outrageous that it doesn't convince anybody at all. But when it came to the court and the way the prosecution opposed even a simple request for a straw, for a sipper to drink from because he's suffering from Parkinson's, that was argued extensively. I mean, to get warm clothing, I mean, any most basic humanity you need to have to say yes to these things. These should not be matters for argument at all. So somewhere I think we've touched a very low point in our functioning as a executive government, where we are instructing counsel appearing for the prosecution to oppose even these basic requests. So this is actually for me unexcusable, and a court which allows the prosecution this kind of a indulgence and says, okay, we'll consider on the next date of hearing whether we should give him a straw or not. There's something wrong with that quote also. I make no bones about this. This does not require any great law. It does not even require a constitution. It requires basic empathy, basic understanding of how our criminal justice system works. And this is actually a stark example of the failure of the criminal justice system. And the sooner we set this right, the better. So I think there can be no excuse at all for what happened to Father Stan Swami. It was a needless death. It should not have occurred at all. It was clearly avoidable. And that we have to continue demanding accountability for these kind of unfortunate deaths of persons in custody. And it's an 82-year-old or 84-year-old. What kind of a flight risk can he be? I mean, what kind of a criminal track record does he have that justifies this being denied a bail? So to me, it seems to be, a very open and shut case. But like I told you, there are judges and judges. So even those hearing this conversation between us, there could be a section of people saying, no, 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 these persons should not have come out, shown any indulgence. The law should be coming down on them with a firm hand. So this is a democracy. We can have different points of view. But to me, if you ask me, I think it is an open shut case. There was no need for Father Stan Swami to die in custody.
I didn't actually say anything on this because you have said it so eloquently, and people should listen to it and they should draw their own conclusion. Now, my next question is again, at times when the executive is dominant, we discussed this a little while ago. Citizens look to the judiciary for balance and currents. Yet there is strong perception that the courts have been hesitant to confront the government, particularly in the present context. Why do why do you think this reluctance has grown?
See, let me straight away answer this. Judiciary reflects what the society is all about, right? It mirrors the divisions in society. It mirrors the differences of opinion in society. And sometimes people ask, are judges under pressure from the executive to decide in a certain way? Suppose as a judge, my thinking, my values, and my choices are no different from those who constitute today's ruling establishment. I'm not under any pressure at all. I'm also a human being. It's not that I've left my politics back at home when I'm sitting in the court. It's not that I've let go of my, predilections. I must confront them in the court. I must ask myself, listen, is my prejudice coming in the way of my delivering justice? On every moment, I must ask myself, every case, I must ask myself, correct? But how many of us are able to do that? See, you're a lawyer till yesterday, and today you're a judge, right? Yesterday, you were a government lawyer, vociferously opposing somebody's bail. Today, you're sitting as a judge. And by coincidence, you're sitting on the criminal roster. Is it fair for us to expect that suddenly this person will become completely impartial? It's not possible. So discerning chief justices will say, let us not give this person who was a public prosecutor the day before yesterday, let us not put him on a criminal roster. We'll put him on a civil roster where he's deciding some second appeal, right? Likewise, somebody's been a corporate lawyer. Let's say a management lawyer in labor cases, very flourishing practice. You don't put him on the labor roster when he becomes a judge. Even the labor lawyers will tell you, sir, don't do this. This person, it will take some time to get rid of all those prejudices that the person has lived with. So I'm just saying that this is something that we need to ask ourselves as a judiciary. How do we hold out ourselves to the litigant public? How do we make sure that these elements of bias, of partisanship are got rid of? So judges don't have to be under pressure to decide in a certain way, but the judges have to ask themselves, are those pressures from within, is something that I'm able to overcome, I'm able to transcend and take an objective view at a case. So this is something that people tend to forget. Also, history tells us during the emergency, you had Supreme Court judges who were the greatest proponents of liberty, constituting the majority to uphold the MISA, right? The very same judges who were eloquent in the public interest litigation, advancing the causes of prisoners under trials who've been languishing in jails, those were the very judges who constituted that ADM Jabalpur majority. So, which is why I'm saying judges somewhere reflect the mood of the nation. So, there are some judges who say, listen, the judiciary is supposed to be counter majoritarian. It is supposed to come to the aid of the linguistic minority, the religious minority, the weak people, because they can get engulfed by the majority dominant viewpoint. And a court has to strike that balance because the constitution wants you to strike that balance, right? Because you're a numerical minority, it doesn't that you don't matter. Scheduled caste and scheduled tribe form, let's say, 22.5% of the population, right? They're a minority in that sense, in numerical minority. Does the constitution say, okay, numerical minorities have no say? Everybody's fate will be decided by what the majority decides? No. The constitution requires you as a state to make a special dispensation in favor of minorities. Right? That's part of the constitutional scheme. So ours is not a majoritarian democracy at all. People make the terrible mistake. Because I have a majority in parliament, what I say should be the law. That's not the constitution, what the constitution says. As a majority, you pass so many things in parliament with or without a debate. When it comes to the court, it will get tested. By your mere numbers in parliament, the law does not become constitutional. Right? That is what you're there as a court for. So likewise, in administrative decisions that you take, every decision, when it is tested in court, there are a set of principles. Is it a fair decision? Is it a non-discriminatory decision? So every time I should not ask myself as a judge, oh, is this decision which I'm taking going against the grain of the majority? Maybe it is. But that is what you're a judge for. You're not a judge to put a rubber stamp on every decision taken by a majority. Why are you given all these protections under the Constitution? Why can you be removed only by way of impeachment? Why has the Constitution given you security of tenure? Because the Constitution acknowledges that the decisions that you take may be unpopular. This may not, be approved by the majority of the population. See, every time that I sit for a case, I only have to look at my WhatsApp or Facebook. How many people will like? I will put on the Facebook a post. I am going to acquit this person and wait for the likes and dislikes. Right? Then majority will say dislike. I'll say, oh, majority have disliked this decision. So many thumbs down. I should not give this decision. So if I'm only going to pander to what is popular, what the majority feels is right, then I cannot function as a judge. Whereas in some judgments, you'll actually find the judges say we cannot ignore the popular voice of the people. You have to be aware and conscious of that. You can't tailor your decisions to please the popular majority. If the decision is inherently flawed, if it is arbitrary, if it is illegal, you can't say, oh, the majority has approved this decision, therefore I'm going to take this decision. Which means then you are unable to function as a judge freely without fear or favor. The word fear is very important there. Fear is not about corruption. Fear is unpopularity. I want to be considered to be very popular among people. So my decision is not based on reason, but it is based on approval of the majority. That can't be the function of courts. If the courts come down to that, they have failed in a very fundamental duty that they're supposed to discharge under the Constitution. Those minorities in our country, whether they're minorities by opinion, by viewpoint, by language, by religion, by caste, they will lose faith in the courts. They will say these courts were set up for protecting our rights, which are enshrined in the Constitution. If this entire system is to be run by numbers, then what is left? So this deep understanding of what the Constitution is and how the courts have to perform the counter-majoritarian task is something I'm finding disappointing that, High Court judges and Supreme Court judges sometimes do not internalize these things.
I think I don't have any other questions
Right.
because what you have said right now, that said all. And and what I want to say is that, okay, a judge is also is an individual. So he has his upbringing, his, you see, his conscience. All these things are very very important.
No, a judge is an individual, a human being who, under the constitution, is expected to grab opportunities to get enlightened.
Yeah, yeah, yeah. And
So we are creating in the constitution a perfect setting.
yeah,
We're telling the judge, there is so much opportunity for you to get enlightened.
yes, because
And
you are
please do that. Yeah, please do that because the whole country is depending on your wisdom.
yes, you are in an elevated position, so you make best use of that,
Yeah,
and,
yeah,
render your
yeah.
service.
So the constant thing of acquiring more experience and more knowledge and disabusing yourself and removing those elements of prejudice from within you. This is the constant exercise every judge at every level of the judiciary in India has to perform. And if that happens, we have a far better future ahead of us.
I want that the judges of our country, they should watch this interview. The advocates, the lawyers, they should watch this interview, and also the laymen, they should also watch this interview because you have not left anything unsaid. You have very clearly, eloquently
Thank you.
said everything. And there
Thank
are
you.
so many things to learn from this and takeaways from this. I'm so
Thank you.
grateful to you for
Thank you.
sparing time. And I would request you also at times, later on, sometimes, to give us this opportunity, because I am reading this book.
Yes.
I'm reading this
Okay.
book very carefully,
All right.
and I'm making notes of these things.
All
And
right.
maybe later on we shall have a conversation only on this book.
Very, very well. Sure.
When
Sure, sir.
when
My pleasure. My pleasure.
when
It's
I
been
finish
great
reading
talking
this
to you. Yeah.
when I finish reading this book, this is a
Yes.
very very important book. And as I said, that the introduction of the book actually that gives such a broad
Correct.
canvas.
Correct.
So really, I'm really, but I feel very privileged that you could spare time for us. Thank you
Thank
very
you.
much. Thank
Thank
you.
you so much. Thank you. Thank you.